So in Module 3, we're discussing the role of the expert witness in forensic psychology. And I know these get a little bit wordy, but let me go through a few things that we need to talk about up front. The legal system, judges in particular, are resistant to legal authority being replaced by psychological evidence. So the evidence has to be solid, it has to be reliable, it has to be valid. The expert witness has to know what he or she is talking about. Purpose of the psychologist as an expert witness is not to replace decision-making ability of the court, but to assist the court. You guys have heard this before in this court. That is the role of the forensic psychology, to assist, not the client, not the attorney, the court. Forensic psychologists usually serve as experts without testifying in court. In depositions, in doing psychological evaluations, in interviewing, often writing reports that are read in court or read by the judge or attorneys or prosecution. So it's not always taking the stand. I think as we think of an expert witness as taking the stand and sharing their professional opinion, but often it's outside of that context. Some of the challenges, it's adversarial in nature. You usually participate in open discussion environments, ideas, conclusions will be critiqued in a combative atmosphere. That's the biggest difference we talked about as opposed to a therapeutic setting. When you're in a legal setting, it's different and can catch people off guard. Conducted in a public place with little support for testifying experts. Expert is truly alone. Yes. I've been called to testify as an expert witness on a few occasions, and it's different. You are alone up there if it's being called to take the stand, and when you're being cross-examined, they can get you on your toes. So it's a different environment altogether. Called the most frightening professional experience in psychology. Yeah, by most psychologists, they would probably say that. Ones that don't have extensive work serving as expert witnesses. History of the expert witness. Many instances occurred prior to the development of clinical psychology. John Johnson's 1846 trial for the murder of Betsy Bolt. Mariah Brigman testified on mental health of one of the witnesses who was a patient at the psychiatric hospital. So that was kind of considered one of the first times that expert testimony was given. Cover up prior sexual assault of Mrs. Bolt by Johnson. Yeah, there was, obviously some things on that weren't on the up and up going on. On the witness stand in 1908, Hugo Husterberg's book encouraged the use of a variety of psychological findings and methods to aid the court in criminal behavior. And then, of course, Jenkins versus the United States in 1962 allowed clinical psychologists to testify in court. As we said, prior to this, it was mostly physicians and doctors. Those that had been to medical school were considered the experts. It created a demand for forensic psychologists. Yeah, this opened up opportunity for the psychologists to get involved. Not just psychologists, but nowadays social workers and professional counselors and a host of people that have backgrounds and licensed in clinical and mental health issues. Admissibility admitted by a judge of expert testimony. The Frye test was what was kind of considered the most dominant standard. Frye versus the United States in 1923 allowed to testify if the theory or procedure was generally accepted in particular scientific fields. So in the Frye issue, the issue was admissibility of expert testimony with a polygraph. Court concluded scientific field did not generally accept polygraph as reliable and valid, and that's been kind of the opinion that went on for many years. When we compare probative value versus the prejudicial consequences, sorry, I have to get that out right now. The probative proves a particular point, and it's very useful in deciding an issue. Yes, probative we consider to be useful. The prejudicial. It has the potential for bias or damaging evidence or testimony that could cause some problems. And you'll see right here, let me move myself out of the way here for a second. Oh, there we go. Balancing test means information an expert conveys must be more beneficial or probative than prejudice or bias that might introduce into the minds of the judge or jury, or it will not be admitted into court. Example might be a past crime such as a previous arrest for murder are generally not admissible in a criminal trial. Number one, such information would bias juries against a defendant unreasonably. Number two, it would be too prejudicial. Number three, it would provide little, if any, probative or useful information in deciding if the defendant was guilty of the current crime. So expert testimony must meet these same standards. Daubert versus Merrill Dow Pharmaceuticals in 1993, we talk about the concept of junk science, which is basically expert testimony on issues that were not well established in the scientific community but were useful to the legal system in some manner. Testimony of big tobacco representatives suggesting smoking does not cause cancer is an example of junk science. So finding some scientific folks out there that'll back them and share where there's no correlation between smoking and lung cancer, for instance, which we know is BS. So relevant, right here, court indicated that in order for scientific evidence to be relevant, it must relate to the issues at hand. The trial judge had the discretion to exclude relevant testimony when the probative or useful value outweighed by the prejudicial impact of the testimony. We consider junk science to kind of be biased and prejudicial. Reliability has to be scientifically valid. Is the theory or technique testable, and has it been? Has it been subjected to peer review or publication, which is really important in scientific review? The scientific method requires peer review, it requires publication, reevaluating it, and building the theory. What is known or potential error rate? So we want to know, what is the error? How much bias is included? What's the reliability, the accuracy as well? Is it generally accepted in the scientific community? That's another question we ask. In General Electric versus Joyner, 1997, judge is the gatekeeper and evaluates methodology. So the judge has that authority to evaluate what we're bringing in scientifically and see if it lines up, or if there is strong support in the scientific community that would allow that information to be admissible. And then Daubert inquiry was applicable to non-scientific testimony in 1999. So there are some cases where there is information that is non-scientific, but it still applies. It answers the legal question at hand, or helps with the legal question at hand. Challenges to expert testimony, cross-examination. This is probably what makes it the most fearful, the most terrified event in psychology. Most common way of challenging an expert witness, rely on the use of a way to challenge expert testimony they believe may be suspect, even though it is admitted. Occurs after the witness has testified and the opposing attorney is able to question the expert directly. Used to discredit a witness or impeaching through the use of inconsistencies that were recorded in the past cases or published in professional materials. Discredit by pointing out other professionals that disagree with the witness. We always, in cross-examination, they'll bring in another professional that has a different opinion of the one for the that has originally testified. Research shows it works, has altered verdict choices in mock studies. So when you bring in another professional, another expert witness, another psychologist, for example, that has information that is contrary to what was presented by the first psychologist, this alters things quite a bit. It's been proven to. Battle for power and control, which kind of summarizes this cross-examination process. Opposing expert can increase the cost of the trial, leave jury or judge kind of confused when you bring in an opposing expert, lead to frequent criticism of dueling experts, and taking focus of off the real issues rather. It can decrease the impact of the defense's expert witness. And we found that with opposing expert, there's modest impact, some empirical support to the help of an opposing expert. It doesn't always work. It can backfire. Judicial instructions, a judge reads a list of instructions to a jury prior to discussion of the case, which the jury is supposed to follow during deliberation process. Juror comprehension is low a lot of times. That's a problem. Doesn't understand the information that's being shared by the expert witness. Many factors impact comprehension of this information. Impact is questionable if how well it actually works. Factors that influence the credibility of, per se, the psychologist. So a host of theoretical factors. Some of these seem kind of common sense. Dressing professionally. If I went in my weekend wear of my Bob Marley t-shirt, my Birkenstocks, and yeah, that probably wouldn't fly. Good eye contact. Not crazy eyes like I just made, but proper eye contact is important. Projecting your voice, speech 101, you guys probably remember a lot of those things are important. Court familiarity, being comfortable there, not feeling on edge, not feeling the adversarial nature. Don't let that get to you. Keep cool, keep your composure, and state what you know. Don't elaborate too much, but be concise and don't share too little. Empirically supported factors, hired gun effect, making experts appear less credible because the experts have been paid by the given side to testify. They will discredit you by talking financial gain for providing testimony because it's pretty true. There is financial gain, and there are some hired guns that make a good living off of providing deposition, providing reports, serving as expert witness. More believable from research. It says experts from local community actively practice, testify for both prosecution and defense. Pro bono, meaning for free basically, for a very, very low fee. That can be done, and it has happened. And so more believable is when somebody's not being compensated. I think the jury is made aware, or they're probably in a non-direct way made aware. This person is providing their expert testimony and they are not being compensated. And that seems to go over well with the jury. Criticisms of expert testimony, talking over the courtroom, informing judge, jury of information beyond their knowledge, and replacing their decision-making ability, especially when it fails to meet standards of scientific testimony. So not coming across like a pompous know-it-all jerk is part of that. Being diplomatic when you share information. Ultimate issue or ultimate opinion testimony, expert testimony in which expert not only gives a conclusion but answers the ultimate legal question that is presently before the court. Psychologists testifying if defendant is guilty or non-guilty. It is beyond the role of the expert. You cannot give a definitive answer. You cannot make a super strong prediction. You got to be very careful. You don't answer the ultimate question. You don't give the ultimate opinion. Corruption of science is the nature of adversarial process, corrupts the objective nature of science and introduces bias into the scientific community. When we're trying to share scientific testimony, we're trying to bring it from an objective standpoint and empirically based, but it loses this when it's in the context of a legal setting. Simply because of the adversarial process, it takes away from the objectivity. There's financial incentives paid for time. Some earn over $10,000 a single case. I should be doing more of that work. Extra forensic relationship. One of the parties involved in the case is a friend or a relative of the expert. Both belong to the same professional organization or church, etc. Yeah, we call these relationships. Well, they definitely taint it. In clinical settings too, you got to be careful that you don't have relationships outside with people that you're working in the context of therapy. Attorney pressure, perform in certain manner of a particular type of testimony. Politics, moral beliefs. Where do you stand on abortion, child custody, death penalty, your own biases? Because we all have worldviews, and how do we leave that at the door, or is that going to be a part of our testimony? Notoriety, limelight, media coverage, public acclaim, loss of objectivity at the risk of seeking this out. You lose objectivity when you're trying to seek notoriety. No doubt about that. And you're probably unconscious of it, but it's something that probably does happen. Competition, another expert will assist attorney if he or she does not. Yeah, you know, if you're not stepping up, you have a relationship with this attorney, they call you, they want you to be involved, they've got other go-tos. So if you turn it down, they'll find other people. If you turn it down on a regular basis, yeah, they'll find somebody else that's their go-to person. Lack of recognition of bias goes unrecognized and affects the process.